When you're hiring employees, it's a good idea to have an airtight employment agreement. Hi, I'm Jane Muir, and I'm a Miami-based business law attorney. If you're hiring employees, there are 5 key things I recommend that you include in an employment agreement. Florida is an at-will state, so you can hire and fire people at will. That means that they can't complain even if you fire them without cause. However, there are certain factors you want to protect in an employment agreement to make sure that someone can't hurt your business if you let them go. Number 1 is you want to protect the confidentiality of your trade secrets. So you want to make sure you have a term for confidentiality. Trade secrets are defined by statute, but it's things like your customer list, your methods and procedures, your devices, the kinds of things that employees have to interact with if they work with you, but if they take it and go to another company or start their own company, that can really hurt your business. So you want to make sure you have a confidentiality agreement that protects your trade secrets. Number 2, you're going to want to have a non-solicitation agreement, because your worst case scenario is a good employee learns all your processes, talks to all their fellow coworkers, and starts another company or leaves the company to go to another competing firm. In order to avoid that, you want to have a non-solicitation clause in your contract that ensures that somebody can't ask their friends from work to leave with them and take them to the new company. The third thing I highly recommend you have is a non-competition agreement. Now, during the Biden administration, by executive order, there was an invalidation of all non-competition agreements, and so we're in a gray area about whether these are enforceable. But in Florida, the case law says that non-competition agreements are enforceable as long as they are limited in duration, in scope, and in geography in a reasonable way. So you can't prevent someone from working in any company at all in the nearest 100 miles for 100 years. That would be unfair in duration, scope, and geography. But if you limit it to 2 years, that's presumptively valid duration, and you limit it to within the nearest 20 miles, that would be a valid geographic limitation, and you limit it to your line of business, like maybe you're a chiropractic doctor and you prevent them from working in a chiropractic clinic, but they're still allowed to work in a physical therapy clinic or in a yoga studio or some other physical activity type of business. That would be considered reasonable. The fourth thing that you want to make sure you cover in your employment agreements is that everything that the person creates is work for hire. There are intellectual property rights that people receive when they invent something or when they create a process or various other things. So in order to make sure that there's no question whose rights are associated with a thing that somebody made while working for you, you want to make sure the employment agreement has a clause that says that all their work is considered work for hire. The last thing I recommend you have in an employment agreement is a non-disparagement clause. What that means is that a person leaving your company can't say they hate you, you're a terrible boss, your company sucks, your clients are getting swindled, that kind of thing. If there's a non-disparagement clause, at least it's a way where you can limit the type of negative communications that somebody makes about you or your company in the public eye. Those are the top 5 things I recommend that you include in an employment agreement.